Hello and welcome back to SEC Roundup. I'm Nick Morgan, founder of ICAN, Investor Choice Advocates Network, and one of today's co-hosts. We're welcomed by a guest host, Patrick Honeyus at Silver Rock Capital, GC and OCC there. Patrick, thanks for joining. I know you've been on this as a guest a few times, so I appreciate you coming on as co-host.
I have. It feels like quite the responsibility.
Yeah, it's a serious business here. And we're particularly pleased to be joined by Ken White as a guest. Ken is a partner at Brown, White, and Osborne and is the co-host of the podcast Serious Trouble, and as many will know, a scholar and student of the First Amendment. Ken, thanks so much for being on.
Thanks, Nick, and thank you, Patrick.
So the thing we want to talk about today is a recent ruling out of federal court in Missouri in a case called SIFMA versus Ashcroft. That would be John Ashcroft Jr., and it relates to the regulation promulgated there in Missouri. Patrick, can you tell us a little bit just about the case and the ruling?
Yeah, sure. So state of Missouri passed two rules, one I believe for broker-dealers, one for investment advisors. The pleadings in the order that we're going to discuss in a second say that the substantive requirements of each rule is more or less the same, so we'll just pretend there's one rule. And the rule required investment advisors or broker-dealers to get a signed consent form from their clients if their advice or their consideration of investments was going to consider social objectives or non-financial objectives. And the form said explicitly that, hey, I, the client, am aware that, quote, this will result in investments not solely focused on maximizing returns, unquote. SIFMA sued to invalidate the rule in federal court, and they had, I think, four theories. We're going to discuss one of them in a second, or Ken will. The four theories were that these rules were preempted by federal law, by ERISA, and by something called the NSMIA, that the rules violated the First Amendment rights of the broker-dealers and investment advisors that SIFMA is associationally standing in for, and then finally that the rules were unconstitutionally vague. And the state moved to dismiss and lost on every argument, as far as I can tell, every argument it raised, including that SIFMA did not have standing to file the complaint in the first place.
And obviously the focus of our analysis here, our discussion here, is the part of the judge's ruling that touched on the First Amendment and denying the motion to dismiss on that basis. Ken, obviously you follow First Amendment issues broadly, and as an SEC practitioner, we occasionally see the SEC try to compel certain types of speech. What do you make of the case and the judge's ruling and the First Amendment impact here?
Well, I want to give the disclaimer. I absolutely did not follow the ERISA portions. I use ERISA litigation exclusively to punish associates. But the First Amendment part is very interesting and part of three trends coming together right now that we've been seeing. Okay, trend one is governments, particularly state governments, using the law to push narratives that I'll describe broadly as anti-woke. So, here you have a state saying, we think all these investment advisors are too woke. We're going to put a stop to that. A lot of it is crowd pleasing. It's not always necessarily intended to stand up to legal scrutiny as much as it is sort of a vote getter and an applause line. The second trend is the courts, particularly the United States Supreme Court, cutting back on exceptions to the First Amendment that in the past have been sort of vague, ambiguous, and broad. So it used to be that there was this general sense that there was a commercial speech exception to the First Amendment that was nearly boundless. It was used very broadly. It didn't really have very good tests or contours. It could be overused by the government. The Supreme Court has increasingly cut that back and put actual standards and tests in place. So you can't just wave the flag, oh, we're regulating commercial speech and get away with anything. So here, for instance, you see the idea that this is commercial speech does not let the government compel brokers to read this particular little script that embodies the government's view of what role social issues have in investment. And the third trend is the courts cutting back on this idea that there's some sort of broad First Amendment exception for professional speech. So there was this idea floating around in the circuit courts for a number of years that regulating professionals speaking in their capacities professionals was different than regulating a citizen speaking as a citizen, and that the government had broader power to do that. And the Supreme Court has now said more or less, no, that's not a thing. You got to fit into one of the other First Amendment exceptions. Because remember, the way First Amendment law generally works is if its speech is protected unless it falls under a established exception. And then you got to use the rules of that exception. And the Supreme Court has said more or less, we're out of the business of creating new exceptions. So this case is part of a series of cases that I see as very similar, where regulations inspired by controversial cultural and political issues result in sort of pushy speech restrictions on different types of professionals. So in Florida, you had the case of the Florida legislature telling doctors you're not allowed to ask your patients whether or not they own guns, because that upset some gun users, and we think you're trying to bully them out of owning guns. And the 11th Circuit eventually said, no, you can't do that. You're regulating the doctor's speech. There's not this broad, bogus professional speech exception. You can't do that. California had a case that got all the way to the Supreme Court, and that was California telling religious-based pregnancy crisis centers that they had to, as part of their message, say, we think you should, choose adoption, choose life, but we're required to tell you here's where you can go get an abortion. And the Supreme Court struck that down, again, saying this was compelled speech. It didn't fall into the narrow definition of commercial speech. Professional speech isn't a thing, so we're striking it down. In that case called Becerra. So this result does not surprise me. And in fact, I would say the Missouri regulations were only barely plausibly calculated to be constitutional. I see them much more as sort of a crowd pleaser and an applause getter than a plausible attempt at an enforceable law.
That's interesting, Ken. And one case you didn't mention that may be appropriate here, particularly since we're focused on SEC issues, is the conflict minerals case, where the SEC compelled public companies to make representations about conflict minerals, and the DC Circuit struck it down on First Amendment grounds, which seems to fit within this sort of same family of cases. So anyway, it's
exactly the bottom line seems to be the courts are saying, government, we're not going to allow you to force people to carry your message, whatever that message is, whether it's liberal or conservative.
right.
And I honestly think that's the right result. The government has its own soapbox, its own bully pulpit. It can put out those messages. It shouldn't be basically fighting the culture war by regulating what professionals can say.
Yeah, interesting. Well, we'll have to follow up on this case and see what happens. This was obviously just a motion to dismiss, so important, but very preliminary in the case. And let's see when the SEC promulgates its disclosure rules around ESG issues, whether this case gets used in that context. So I guess we'll find out. But in the meantime, thank you very much, Ken. Thank you, Patrick, for being on. Everybody else, we'll see you at the next SEC Roundup.